Hello, my name is Ian Hasenfleck and I'll be talking about third-party rights for my Business Law 230 IPP. A brief overview of what I will be discussing in this presentation. I'll talk about general information of third parties, troubles with third-party rights, two types of third-party beneficiaries, requirements for a third party, assignments of a contract and the 7 aspects of an assignment, delegation of duties and when duties cannot be delegated, what is novation, and third parties and ethics. First, general information. These contracts are called third-party beneficiary contracts. These were created to protect the interests of parties who were not directly affiliated in an agreement. A third party has the right to enforce a contract even without having direct affiliation. This used to not be the case. Privity of a contract would prohibit anyone who is not a party in a contract from enforcing terms of the contract. This essentially would bar third parties from enforcing a contract. However, courts have ruled away from privity, allowing third parties who benefit from a contract to enforce these rights. A third-party beneficiary contract is the only exception for contracts not between two parties. For this to be acceptable, there must be a relationship between the stipulator of a contract and the beneficiary. So a third-party contract would essentially be between, for example, a father and an insurance company. The father passed away, the daughter would benefit from all the insurance money from that insurance company. So even though the contract is between the father and the insurance company, the daughter would benefit from the terms of the contract. Trouble with third-party rights and restatements. In the early years, common law had refused to give third-party rights in a contract due to third party not having privity with the original parties, essentially a relationship. Although courts eventually realized that third parties do have rights within a contract. The first restatement of contracts gave third party the rights to enforce a contract, gave the original parties the right to make changes in the contracts. This restatement created two types of third-party beneficiaries, the donee and the creditor beneficiary. I will discuss more of this in the next slide. However, courts realized that most third parties do not fit into these two types of beneficiaries. Therefore, the second restatement fixed the issue of third parties not fitting in each category, which held up results of contracts when they were being settled in court. The second restatement introduced intent. This will be discussed in another slide. Third-party beneficiary contracts. Two types of third-party beneficiaries are the donee beneficiary and the creditor beneficiary. The donee beneficiary is a third party who receives a gift when a promisee secures a promise from a promisor for making a gift to a third party. They are technically not a part of the contract, but the donee beneficiary benefits from the contract. In this contract, those parties that are in the contract are known as the donor and the donee. Once the contract is completed, the donee beneficiary will benefit from the contract. An example from Investopedia outlines how this type of contract works. Sam, the donor, promises a gift of a gold watch to Phil, donee. To get this watch, Sam will buy it from Mike, a third party. In this case, Mike is the donee beneficiary in Sam and Phil's exchange. If Sam went back on his promise, Mike would not sell the watch. Mike benefits, but is not actually a part of the contract. A creditor beneficiary is a third party who receives the benefits of a contract made between two contracting parties for paying one original party's debt to the third party. An example would be if Party A needed to pay a creditor and Party B promises to pay Party A's debt. Requirements for third-party contract. A third party has the right to sue is known as an intended beneficiary. This means the third party can enforce a contractual promise. However, there must be a contractual provision that proves that the third party is an intended beneficiary. So, as described before with the second restatement, third parties must show intent in the contract. So if there's no direct intent with the contract for a third party, then the third party cannot enforce its rights. If the third party is not an intended beneficiary, they are known as an incidental beneficiary. The third party benefits from a contract. However, they are not intended to benefit from the contract. So they will benefit from the contract even if they don't have an intent in the contract. Therefore, the third party does not have the right to sue to enforce the terms of the contract. So essentially, the third party, if it's an incidental beneficiary, would not have the right to sue or enforce the terms of the contract. An incidental beneficiary does not include a donee or a creditor beneficiary. Third parties do not have to be aware of the contract when the parties are signing agreements. A third party only becomes active when an agreement of the contracts are met. So this essentially means that if the third party doesn't need to know about the contract or doesn't have to be there for the signing, whatever, it's when the requirements are met of the contract between the two parties, then the third party would benefit, and that's when the third party has the right to sue or enforce the terms of the agreement. So if party B did not complete the terms of the contract with party A, that's when the third party can essentially come in. This is known as vesting, when courts look for the event that would give the third party the rights to enforce the contract. An example of vesting is when someone would receive money in the event of a person's death. Once the death occurs, the third party is vested with the rights. A third party must be clearly stated in the contract to have intent to the benefits. What is an assignment? Each party of a contract is an obligor and an obligee. An obligor is a debtor or a promisor, and an obligee is a creditor or a promisee. An obligor is the party obligated to perform the duties of a contract. An obligee is the party entitled to receive the performance of the party. An assignment is a transfer of rights. This occurs when one party transfers the rights or duties to another party. The assigner of a contract would be the one to make the assignment and transfer the duties and rights to the assignee, the one receiving the assignment. The assignee must be informed that the assignment will occur. The assignment occurs in a bilateral contract, meaning the rights go from party A to party B. The assignment also occurs in third-party contracts. However, the third party may not add terms to the contract without having consent of the original party. Some rights may not be assigned, however, due to statutes. While this kind of action is common in real estate contracts, such as rental agreements, a tenant cannot rent out, for example, a tenant cannot rent out a house to a new person without having the landlord being informed. There are 7 legal aspects of an assignment, which will be detailed more in the following slides. So they include consent under the code, anti-assignment clause, claims for money, rights of the assignee, obligation of parties, and notice of an assignment. Consent. Parties may or may not receive notice when they are given rights or duties. Signers do not need a party's consent when giving said party rights and duties. The general rule of an assignment is that one party may assign rights without the consent of another party. There are exceptions to this general rule. The first exception is that there are some rights, including personal or duties, that may need consent of the other party. There needs to be a trust for a person to perform these rights or duties in a consent. Either a specific person or a specific set of skills by a certain person is needed. Therefore, consent is needed for this contract. So essentially, like, if party A and B make a contract, party B has a special set of skills. Well, party B cannot pass the rights onto a third party because party A needs party B's skills. The second exception is that if there are multiple rights and duties involved in the contract. In this case, personal rights will not be assigned to assignee. The exception requires an obligee's consent. The third exception is if the assignee obligee takes on additional burden or risk to the rights or duties being transferred. This exception protects the second or third parties as they may not be able to fill the rights or duties. An example would be a payment on credit. The last exception is when rights are transferred, the assigner is not relieved of any liability even if the assignee is given consent. An example from our textbook would be if Ryder leases a truck to a second party. The party then, with the approval of Ryder, leases the truck to another company. When the third party fails to pay rent, Ryder can hold the second party accountable. So liability is not taken away when rights are transferred. Consent required under the code. The Uniform Commercial Code has provisions that usually approve of assignment of rights and the delegation of duties for buyers and sellers. Duties of an agreement may be delegated to parties unless it is stated that parties have agreed not to be delegated based on the non-delegating party having interest in the original party to complete the duties. This appears in the UCC 2-10, Section 1. A party may perform his duties through a delegation unless otherwise agreed or unless the other party has substantial interest in having his original promisor perform or control the acts required by the contract. No delegation of performance relieves the party delegating of any duty to perform or any liability for breach. Lastly, under the Uniform Commercial Code, if an assignment were to change the duty of another party, add more risk, or interfere with the party performing, then the assignment cannot be consented to. Anti-assignment clauses. Anti-assignment clauses are placed in contracts to prohibit parties from assigning rights and duties to other parties without the consent of the other party. The assignee of a contract may not assign the rights to a third party without the consent of the original assigner. Some contracts may not have this clause, and therefore rights can be assigned without consent, if they are included in the exceptions from the previous slide. According to Aaron R. Katz, a common anti-assignment clause may say no party may assign any of its rights under this agreement by operation of law or otherwise to a third party without the prior written consent of the non-assigning party. Some cases have seen that clauses to be against public policy, and courts not hold these clauses to be unenforceable. Courts now have found that these clauses hold up and can be enforceable. Under the Code, anti-assignment clauses have been found that rights can be assigned without consent, but delegation of duties needs consent. Claims for money. Another general rule of third-party beneficiary contracts is that claims for money due or to be due may be assigned. Often in a sale, people may assign part of their wages to satisfy an obligation. However, there are certain situations, such as that a seller cannot take an assignment of earnings or a payment of debt out of credit sales. Certain aspects such as these are protected under the Uniform Commercial Credit Code. The Consumer Credit Code of 1974 was created to protect consumers and debtors. Often, when there is money involved, parties will be worried about if another party fails to pay, who is then liable. It depends on the assignment. If the assignment is a security for debt owed, the assigner will be liable to pay the debt. If the assignment is a purchase for a claim against a third party, then the purchaser will have no legal right against the assigner if the third party fails to pay. If the claim is invalid, then the assigner would be responsible for paying the assignee if the third party failed to pay. Lastly, if there is a warrant, then the third party is obligated to pay. If the warranty is breached, then the assignee would take legal action against the assigner. Rights of the assignee. When assignment occurs, rights are transferred from the assigner to the assignee. When this happens, the rights of the assigner will be endowed onto the assignee, giving the assignee equal rights as the assigner. However, with this, there are downsides to the assignee acquiring the same rights as the assigner. If a third party decides to sue the assigner, the assignee would be liable as well. Due to them sharing the same rights, they are equally responsible. Defenses for a third party towards the assigner and assignee would include partial payment, fraud, duress, or incapacity. The waiver of defense clause in a contract gives the contracts a negotiability quality. However, this quality would be cut off the defense of one party and give protection to another party. The party that is Granted, the protective status is known as the holder in due course. However, even though this clause may be more marketable, the Federal Trade Commission has deemed this legal as it is an unfair method of competition. Obligations of parties. Obligations are duties in which parties are legally responsible for. If a party does not take care of their obligations, they would have breached the contract. Obligation of parties will depend on the type of contract, whether it is a service contract or a rental contract. Obligations can be satisfied by either payments, delivery of good or service, or the quality of the goods. These type of obligations are subject to the contract. Parties are still liable for their obligations in the event of assignment. When assignment occurs, the transfer of rights, this does not include the delegation of duties. Therefore, a party is not responsible for duties. The assignment of a contract would include the rights and delegation of duties if the entire contract has been assigned. So when the assignee takes on the rights and duties, they are liable if there is a failure to meet these obligations. Under the Code, unless otherwise stated, an assignment of a contract will include both rights and duties. The contract must state that duties will not be delegated. Notice of an assignment. After an assignment, the assignee of a contract needs to inform the obligor or the debtor of the transfer of rights. Many assignments do not need to be notified immediately in certain cases. If there is an absence of notice of an assignment, then the third party can pay or complete what the contract stipulates in the assignment. This simply means that the obligor did not have the knowledge that someone else was taking over the rights of the contract, and therefore the third party may complete the contract of the original assigner. The right of the assignee would not be able to request performance of the contract due to the failure to notify the third party about the assignment. However, if the third party does not receive notification of assignment, then the third party must complete the agreement of the contract to the assignee. Secondly, a notification is needed to protect the third party. Essentially, the rights can be given again in the same manner. Essentially, rights would be doubled up. If there is not a notification, then the third party may choose to take whichever assignment. So whichever assignment comes first, the third party has the right to choose which one the third party would like to complete. It is important that there is a communication between the assignee and the obligor to make sure that the rights have not been already assigned. Simply, multiple assignments can be given. The first assignee to notify the obligor will have the priority. Delegation of duties. Delegation of duties is a transfer of third party of the duty to perform under a contract. Along with an assignment, the transferring of rights, delegation also occurs. The party who delegates the duties is known as the delegator. For example, in a contract between party A and B, rights and duties will be passed from A to B. However, party B can delegate the duties to perform to a third party. A third party will then perform the duties to satisfy the agreement. Even though party C has now the duty to perform, party C will be liable for the duties of party A. Though there are three circumstances in which delegation of duties is not allowed. First, the circumstance is if there is a provision within a contract that bars delegation of duties. This is known as an anti-delegation clause. In this case, party B cannot delegate the duties to party C. The second circumstance is if the duties to be performed are personal. Again, this is if party C or party B has a certain set of skills that are needed for party A. For duties to be personal, the contract must call for a special skill or talent that only the party can perform. Party A and B may enter a contract for party B to perform a special operation for party A. If party B holds this special skill or talent, he/she cannot delegate this duty to party C, as party C does not have the specific skill or talent. Lastly, public policies may prohibit delegations. An example would be if an elected official delegated the duties of the office to a private citizen. This would go against public policy, as the official was elected to perform the duties. However, duties of an official could be delegated to an assistant or subordinates. Novation. Novation is an agreement where a new party would replace an old party. In this situation, a new contract will be made to make note of the new changes. A new party of the contract would inherit the rights and duties of the old party, relieving the old party of any liability. Novation derived from Roman law meaning substitution. A new party of a contract would be substituted for the same rights and duties of the original party of the old contract. An assignment, an example, would be if party A made a new agreement with party C, substituting for party B of a contract. The new contract would reflect these changes. For novation to occur, all parties must agree to these changes. So a new contract novation cannot occur between party A and party C without party B and party A and party C's consent. So everybody needs to consent to these new changes of novation. Lastly, third-party beneficiaries and ethics. One way that I've found that third parties and ethics are related is that the benefits of a third-party contract received by third parties may be acquired unethically. So if party A and B committed fraud, and party C benefited from this fraud, whether it could be through fraud, theft, or other behaviors that are legal or unethical. So benefits could come from unethical or illegal means through a contract. Third-party beneficiaries may act ethical and may not accept any benefit that would be acquired through unethical means. However, this depends on the ethical decision-making processes of the individual. So it's up to the individual to decide if they are willing to accept these benefits from unethical means, or if they will deny these benefits because they hold strong ethical values. In some cases, the benefits that a beneficiary would receive may have been acquired unethically, but the beneficiary does not know that these benefits were acquired unethically. So essentially, I could accept benefits from a contract, and I wouldn't know that these benefits I received were acquired unethically. It just depends on how much communication is between the parties. So essentially, it all depends on the individual ethics. If someone has strong moral values, holds a good ethical code, then they may not accept these benefits from unethical or illegal means. But it depends on the individual itself. Well, I'd like to thank you for listening, and sorry I stumbled a lot. I'm a little nervous first time doing this, so I appreciate you watching, and have a good rest of your day. Bye.